Hey everybody, welcome to our live stream. I'm Paul Rabelais. I'm getting these live streams are kind of growing on me. I've made hundreds of videos and a lot of them are scripted in front of the camera. But these live streams, which we've been doing for the last few days, really like the participation and kind of a community aspect to it. So anyway, today, how to make your children's inheritance divorce proof. This is the topic that, boy, really gets people kind of motivated to really get their estate plan, get their estates in order. So we're going to dive into the specifics of that today. We're going to talk about this problem that can happen if you don't address making your children's inheritance divorce proof. We'll talk about the typical solution or solutions that are fairly easy to implement, and then we're going to dive deeper into some of the little bit unusual situations that require greater protection. Okay, so I do want to encourage you to hit the chat, share your questions. Ideally, it's a question that's relevant to the topic at hand. Want to get you to even share your experiences that you've had with the topic at hand, and even just positive comments. So the more the chat, the better. I'm going to present some information, then we'll wrap it up by going to the chat and addressing those questions there. So let's jump right in. All right, so most people don't even really kind of think about this as a potential problem, but once they hear about it, they're like, I want to make sure we address that. So let's jump right in. So the common problem is parents pass away and they leave their children. Let's just say they have three children, and so they leave each child an inheritance. And the moment that the child inherits it, and the moment that he receives it, it's his property, that's not owned in any way by his or her spouse. It's not community property. It's not joint property. The moment he gets it, it's his. However, let's say that child inherits $1 million. And what happens either immediately or along the way, the child commingles that inheritance with other assets that the child has with their spouse. Maybe he drops that $1 million into a joint account. Maybe he invests some in a brokerage account. Maybe they go out and they buy a house together in both of their names, and they use some of the funds that he inherited and some of the funds that the couple had together. Anyway, that inheritance can and often does get mixed up together, commingled, mixed up with other assets that the child who inherited had with the child's spouse. And then lo and behold, months later, years later, perhaps even decades later, the child gets divorced. And the problem is the child loses half of their inheritance, if not more. So the child, they didn't retain that separate status that they needed to retain because for one reason or another, it got commingled, either just unintentionally or accidentally, or maybe the child's spouse has, exerted some influence and finagled things in a way so that upon a divorce, they have to split everything. So that's the problem. So let's jump right into what a solution is. And I'm going to call the solution creating an inheritance trust for your child, or inheritance trusts for your children. So let's say little Travis, and maybe he's not so little anymore. Maybe he's 30, 35 years old. And so mom and dad, maybe, and let's say Travis is one of three children, but I'm going to pick on Travis. He's married, and maybe mom and dad don't really like Travis's wife too much. And I don't want to get into all that, but let's just, call it what it is. A lot of parents come to me or talk to me and say, yeah, Travis got married, and his wife, we're not too sure about her. And maybe they say he does whatever she tells him to do. Maybe the parents say our daughter-in-law doesn't allow us to see our grandchildren as much as we'd like. Maybe they say our daughter-in-law, if she gets a nickel, she spends a quarter. Maybe they say our daughter-in-law doesn't even come over on our birthday or at the holidays. Our son has to come over by himself. So anyway, there could be any number of reasons why this is kind of a big issue to parents. The parents are saying, you know what? We just want what we've worked for to stay in the family, to stay in the bloodline. We've worked hard for it. Yes, we're not going to sacrifice much so that our children, have to receive an inheritance, but it's likely that we're going to have assets left behind, and we want them to be for our children. We don't want them to be for our children's spouses or our children's future ex-spouses. So a common answer is to, when you create your estate plan or when you restate your estate plan or you amend things, you create for each of your children. I'll say, let's talk about the hypothetical, married couple with 3 or however many children. You create what's called an inheritance trust for each of your children. And so the idea there is, let's say Travis is one of 3 children. You leave Travis's 1/3 to the Travis Inheritance Trust. I'm calling it an inheritance trust. Maybe other people will call it different things. That's the problem with estate planning. There's no standard title or definition for a certain strategy. So people use their own lingo. I'm calling it the Travis Inheritance Trust. And so the idea, if Travis is going to inherit $1 million, that's going to go into accounts titled the Travis Inheritance Trust. It's not going to go into the bank account or brokerage account of Travis and Travis's wife. It's going to go into the Travis Inheritance Trust. And so that right there, that should start to paint the picture that those inherited assets for Travis are not going to be mixed up or commingled with other assets that Travis has with his spouse. So the general idea here, I'm going to fast forward and come back, is if Travis later gets divorced, he gets to keep his trust assets, and then Travis and his spouse split up the other assets that they've acquired during their marriage. So couple of variations here among inheritance trusts is who's going to be the trustee of the Travis Trust. I would say it's most common for parents to say, you know what, we'd love to protect our children's inheritance from their future divorces, but we want them, they're mature and they're responsible and they have a good spouse, but Paul, you just never know. So I get that when parents feel strongly about wanting to protect their children's inheritances from their children's future divorces, the most common thing that they say is they preface it with something like, Paul, we really like our daughter-in-law. Paul, we think a lot of our son-in-law. And then here it comes. But Paul, you just never know. If I had a nickel for every time parents talked to me and they said, Paul, you just never know. So we want to do what we can to protect our children's inheritance from their divorces. So there's some variables there. I would say, and it's common for when we ask those parents who should be the trustee of Travis's inheritance trust. Most parents say, well, we want Travis to be the trustee because while we want to protect it from his inheritance, we don't want to restrict him in any way. We don't want him to feel like he has to ask somebody for permission to receive a distribution or spend some of his inheritance. So let's make Travis the trustee of the Travis Inheritance Trust. And that way, Travis really stays in control of that trust. If he wants to take a distribution out and go take a trip around the world, he can do it. If he wants to have the trust purchase a piece of property or purchase a home, he can do it. If he wants to take all of the money out of the trust for whatever reason, maybe his wife influenced him into doing that, he can do it. So there's some pros and cons there of naming the child as the sole trustee of the child's inheritance trust. The pros are you're not disrupting the fact that you want your child to be able to control their inheritance and you don't want to put any restrictions on them. But the cons are your child, since they are the sole trustee and they do control when distributions are made from the trust, they could make some mistakes. Mistakes could be spending the money unwisely. The mistakes could be being overly influenced by their spouse into undoing the trust or spending the inheritance on things that they really, that you would not envision wanting them to spend things on. So when the child is the trustee of their own trust, the child could be influenced into making bad decisions, or the child could make mistakes themselves. All right, so so that's kind of divorce protection 101. Leave the assets to a trust. The trust lasts for the rest, at least the rest of the child's lifetime. So the child will always hold those assets in a trust, won't get mixed up with assets they have with their spouse. Kind of divorce protection 101 is let the child be the trustee, but there's some pros and cons to that. But we see that often. But now let's say the parents say, you know what, that's not enough for us. We want more protections in place. We know, and like, I've heard it all, but parents will tell me something like, we want Travis, we want him to get his 1/3. You never know, he might get divorced in the future. But they'll tell me one of two things. That daughter-in-law of ours, Travis is going to do whatever she tells him to do. She just exerts too much influence over him. And if he's the trustee and he has the ability to take the assets out of that trust and commingle them with other assets that he and his wife had, she's going to get him to do that. Or maybe they'll say, you know what, Travis he just doesn't make good financial decisions. And so I'm not sure about, naming Travis as the trustee of his inheritance trust. So for a couple of reasons, one, the spouse exerts too much influence. One, your child may not be quite financially mature enough to handle a lump sum of an inheritance like that. Sometimes parents will say, no, we don't, kind of an extra step here in the divorce protection is, we want to leave Travis his 1/3 and we want to leave it in trust for him. But we don't want Travis to be the trustee by himself. We don't want him to be able to be influenced by his spouse to undo the trust. So let's name either someone else as the trustee of Travis's trust, or maybe let's name Travis and someone else as co-trustees of Travis's inheritance trust. And that way, if Travis's wife says, Travis, go get $250,000 out of that trust because I want to go buy a new car and I want some jewelry and I want some clothes and I want to go to the Taylor Swift concert, then Travis can't do that by himself. He's not the sole trustee of his inheritance trust. It requires either that other trustee or co-trustees together. If you name co-trustees, you have to be careful how you set that up. Can either co-trustee act by himself or herself, or if you do have co-trustees, two co-trustees, do they both have to act together to take action as co-trustees? Or if you have three or more trustees, does it take a majority, for example, of the co-trustees to take a trust action like a disbursement to a beneficiary? So sometimes parents will take this divorce protection a step further. Yep, let's leave Travis's inheritance to a trust so it doesn't get commingled with other assets that he has with his spouse. That way, if he gets divorced, he'll keep his trust. He and his spouse can split other assets that they've acquired during the marriage. Let's not make Travis the trustee of his trust because we kind of don't trust him. And but in a loving way, they often say. So then maybe someone else is the trustee of Travis's trust, or Travis and someone else are co-trustees of Travis's trust. That way, if Travis wants a distribution from the Travis trust, he's got to get the permission of somebody else or the agreement or the consent of somebody else to get that distribution. That can keep Travis from making a mistake, and that can keep Travis from being adversely influenced by his spouse into doing something that the parents would not have wanted Travis to do. So there's maybe additional benefits from naming someone other than Travis as the trustee of Travis's trust, or naming Travis as merely a co-trustee where he can't do things by himself. That not only prevents the influence, but if Travis, if there's a concern that Travis might have creditor issues one day, maybe he has tons and tons of credit card debt, maybe he's entered bankruptcy before, maybe he has a big tax bill, maybe he just spends money and he's tinkering on the edge at all times. By leaving things the right way to the Travis Trust, naming people other than Travis as a trustee or co-trustee of Travis's trust, and making it what's called a spendthrift trust, so that Travis's creditors can't seize Travis's interest in the trust. Naming others as a trustee or co-trustee can provide that additional creditor protection if that's desired. So bottom line here is how do you do this? So it's really done when you create your estate plan. If you're starting with a clean slate, Paul, we're 50 years old, we're 60 years old. I know, don't fuss at us for procrastinating, but we've procrastinated. I've been working hard. Now I'm retired and I have a little time to address to these things. So when you're starting on your estate plan with a clean slate, then that's really the ideal and easiest time to put all of this in order. We don't have to go back and amend or change things that you may have done recently or may have done a long time ago, although that's possible as well. So you get this done by, if you're starting with a clean slate, Paul, we're just getting started, but we want to make sure that we protect our children's inheritance just in case they get divorced. That's a great time to do it. Then either in your will or in your living trust, whichever plan you create, if you create your will plan, then, and you have 3 kids and one of them is Travis, and you want things to go to your 3 children equally, your will or your trust will likely say, when I pass away, or after me and my spouse both pass away, we would like 1/3 of these assets to go to the Travis Trust, 1/3 to the Melanie Trust, and 1/3 to the Taylor Trust, whatever the case may be. And then in those trusts, in Travis's trust, for example, it's built in there and customized in there who's the trustee after the parents die, when can distributions be made to Travis. Maybe even it says that when Travis reaches the age of 50, or when he reaches the age of 55, then he can be the trustee of his own trust. So there's not these restrictions, in when his marriage is just being tested, so in the first few years of his marriage, if marriages are likely to fail, it's likely to be in those early years. He's not a sole trustee, but once that has passed the test of time, and Travis, whatever age, it might be 50, then Travis can become the trustee of his own trustee, still protected from his divorces, but then he's put in that total control of whether distributions are made to Travis. So there's options like that. So you, in your last will and testament, if you have a will plan, or in your living trust, as many people create living trust to avoid probate, in your living trust, the language is included in there. When I pass away, when we pass away, if we're married, we want 1 share for each of our children, and their share shall be placed in their inheritance trust under the following terms. So real easy to set up when you're starting with a clean slate. If you already, I have a lot of conversations where people did create their formal estate plan maybe a year ago, maybe 5 years ago, and this thought of divorce protection never came up for one reason or another. And then the parents hear about it and they want to have those protections in place. In fact, there's some lawyers out there that say a child should never inherit just in their own name. I'm not going to go that far. I'm going to go as far as let's do things like this to educate you on what your options are and allow you to make educated and informed decisions. But but I've read things and heard things from other lawyers who have said a child should never inherit in their own name. So let's say you create your estate plan. A couple of years later, you're like, boy, now I'm hearing about this divorce protection. We didn't include any of that in our estate plan when we created that a couple of years ago. Well, now if you have a will plan, you'll need to rewrite your will and also create these inheritance trusts so that in your will you can leave your estate to your children's inheritance trusts instead of leaving assets to them directly, or you can restate your revocable living trust so that, again, when you pass away, assets go to the various inheritance trusts, and the terms of those inheritance trusts are either created as subtrusts within your living trust, your restated living trust, or you'll create standalone. If you have 3 children, you'll create what I call standalone inheritance trusts. One standalone trust for Travis, it's its own trust instrument, and one for each of the 3 children. And then in your living trust, you say, after I pass away, or after we pass away if we're married, then 1/3 to the Travis trust, 1/3 to whatever Melanie trust, and 1/3 to the Taylor trust. So really simple to create as part of your getting started from scratch estate plan, getting it underway, but also doable when maybe amending or restating an existing estate plan. All right. So now what we'll do is let's hop over to the chat, see what we've got there. So if you got a question in the back of your mind about, boy, now that we're in a community here and there's several people reading the chat and there's Paul here on the screen, I sure would like to know the answer to this question. Now's the time to throw it in the chat. And I'm not guaranteeing, I've got a handful of questions there, not guaranteeing that I answer everyone. In fact, if it's off topic and it requires a lot of additional discussion, I'm probably going to skip over it. And then I'll perhaps either address it elsewhere or address it in a future live stream. So what is the best, LJ says, hi, Paul, what is the best methods you recommend for divorce proof and protected from if they are sued for liability? So there you go. It's typically you're leaving assets in trust for them. You're setting it up so that your child is not the sole trustee, because if your child has the ability to go into their trust and take distributions out of their trust or even undo their trust, if your child has the ability to do that by themselves, then your child's creditor is going to have the right to do that on their behalf. So you would name someone else as the trustee of your child's inheritance trust. And then you would include what's called spendthrift provisions in the trust, which essentially say, to the maximum extent possible, a beneficiary's creditor cannot seize their interest in their trust. Also means that a child can't sell their interest in the trust. So, but the quick answer, you leave assets in trust for your child, name someone else as the trustee. That way, since your child has no ability to dip into their trust, your child's creditor has no ability to dip into their trust. All right. Hey, Lynn, New Hampshire. Nice to see New Hampshire in the chat today. LJ, men need to learn to protect their separate property prior to marriage and never commingle it all the way through their estate planning. So I would say probably men and women need to learn to protect their separate property. So had a long Zoom call yesterday with a business owner. The couple and their son is also an owner in the business. The son is getting married. And so really important to that business be kept in the family. So there's all, strategies there for there's at least options for prenups, for other legal documents, for trusts. So lots of options there. Just need to make some informed decisions. LD, if child put an inherited house in a trust, does this protect the house if they are sued as individuals? I would say generally speaking, if you inherit a trust in your own name and then you put your own house into a trust and you are a beneficiary of that trust, I would say that's the lowest level of asset protection. That's not good. However, if let's say you inherited that house from your trust. If your parents' estate planning provided that upon their death, their house was to go directly into a trust for you, much greater asset protection there. But putting your own assets into a trust for yourself, very little, if any, asset protection. Asset protection is a complicated area. But these kind of first party or self-settled trusts where people put their own assets into a trust for the benefit of themselves, very little asset protection there. Okay, now if you inherit a house and you put it into a trust for your children and you do it before this incident that where a claim has arisen against you, should be all good there because it's not your house anymore. It's in a trust for your children or for others. All right, LD, I'm definitely going to do this for my daughter's inheritance. She made a poor choice for husband and can see potential problems given the opportunity for him. Hopefully, your daughter's husband doesn't watch too many of these videos and doesn't, learn any of my strategies or even read your comment. So anyway, let's go to war. What about creditors of your child's spouse coming after those assets? Creditors of your child's spouse should be all good there. And again, there are creditor laws, state laws, there's bankruptcy laws, lots of different issues, but having it go into a trust a spendthrift trust for your child is about the best kind of protection you can do to protect it from your child's spouse's creditors. So obviously we may want to know a little bit more about that, but certainly no problem there. LJ, the problem is the Travises of the world being their own trustees. They can't imagine their spouse will go exorcist on them later. Thus they commingle it. Yeah. So many, let's say Travis, he loves his wife and he's going to do whatever she tells him to do. He loves her and they're going to make decisions together. And some of those decisions may not be what Travis's parents would have wanted Travis to make. So that's why the parents can exercise a little more control by setting this up rather than just dumping the inheritance into Travis's lap. So good question there. LD, when kids inherit, let's see, Tyler. Hey, Paul, any advice on being stepped up per stirpes in the inheritance of my grandma? My dad passed away and now myself and brother and sister represent my dad. And okay, grandma is in hospice. Okay, I see there in your question, you use the word stepped up. So I'm wondering whether you're addressing the step up in basis. If you are, let's deal with it. So that step up in basis when grandma passes away is going to happen automatically, regardless of who her assets go to. But it sounds like since your dad has already passed away and you and your two siblings are going to inherit what your dad would have inherited. So the step up in basis, it just happens automatically. So I don't know if there's other questions there about how to, make sure you inherit what you're supposed to inherit. I don't know if there's any kind of issues there about the process of the three of you stepping into your dad's shoes. But when you say the word stepped up, I don't know if you're referring to step up in basis, but again, there's nothing you need to do. The step up in basis is typically lost when someone transfers or gives or donates assets, appreciated assets during their lifetime. They donate those during their lifetime. The recipient receives it at a carryover basis, which can be a big mistake. It's often better from a tax standpoint, capital gains tax standpoint, for instead of donating appreciated assets to people during your lifetime. I know it's a nice gesture and people may very much appreciate it, but if you bought Apple stock for $10 a share and now it's worth $200 a share, if you give that share to someone during your lifetime, their basis in the share of stock will be $10. Whereas if you just keep it, let them inherit it when you die, then it gets to step up in basis. Their basis will be the value on the date that you die. Let's call it $200. That $190 of appreciation will completely go untaxed because you left it to them as an inheritance. All right, LD, when kids inherit percentage of retirement accounts, they are step into separate accounts, but have to be liquidated. Yep. Okay, so yeah, you're talking about the Parent passes away with a traditional IRA, names 3 beneficiaries. Let's say the IRA account was worth $1.5 million. The 3 kids are 3 equal beneficiaries. That IRA will be divided up into 3 inherited IRA accounts. Each child will have a $500,000 inherited IRA, and they will have to take the RMD, required minimum distribution. It used to be years, before, a couple of years ago, if they wanted to, they could postpone distributions over their life expectancy. That rule went away. Now they have to take the distributions within 10 years after the parent passes away. So sometimes parents feel like, you know what, my child will blow it. If they get $500,000, the minute that $500,000 goes into their inherited IRA, they're going to remove it. And yes, they're going to have to pay income tax on it. Let's call it $150,000 of income tax. And hopefully, the financial institution will withhold that tax, and, he'll wind up with a net $350 and it'll be gone in a month. So some parents will name a trust as the beneficiary of that retirement account, either to force kind of a payout over a certain number of years. A lot of parents say, we realize that they have to get the distributions within 10 years. So at least let's give them maybe 1/10 of it each year over the 10-year period, comply with the 10-year required distribution rule, but they don't get it all in a lump sum. It'll go into a trust. We'll name a trustee. They'll dole it out to Travis or whoever, over that 10-year period. That way he won't blow it all at once. Or they might say, since we know Travis is going to blow it, we want it to go into a trust, and we want it to last much longer than 10 years after we pass away. So now that has income tax consideration, where the trust has to take the required distribution and pay trust income tax at higher trust income tax rates. But nonetheless, the funds are kept from Travis and can be kept from Travis over a much longer than 10-year period. So that's all the conduit trust, accumulation trust. That's all a separate live stream. Look forward to that one day. All right, let's see here. Keeping kids in inheritance separate and not commingle. Good, freedom forever. I think you were answering the question. LJ, sadly, I've had a front row seat to what Paul is discussing. People change in unimaginable as they age. I think it was Dear Abby said, if you ever want to really get to know someone, share an inheritance with them. David Clark, most of the people I would trust to be a trustee for my daughter's trust are old like me. How do I address the potential demise of a trustee? Good question. So a lot of people say, love the concept of leaving things in trust, but I don't have anybody who could be the trustee. And so that is a real problem out there. And so in your case, you asked trust or old. So there has to be some mechanism for determining if there is a vacancy in the office of trustee. Maybe you did appoint somebody old and they die. So either before this trust is funded or while the trust is in existence for your daughter. What happens then? You don't have anybody. There has to be some mechanism for determining how a trustee would be selected in the event of a vacancy in the office of the trustee. So now we talk about, okay, is there anybody else out there? And maybe the answer is no. Then maybe you could say, well, your daughter could appoint a trustee. I'm just throwing things out there. Your daughter could appoint a trustee, or so-and-so could appoint a trustee in the event of the vacancy in the office of the trustee. If there's enough dollars there, you could always go to the default. In the event of a vacancy in the office of a trustee, I appoint XYZ corporate trustee as the trustee. But those corporate trustees don't want to participate unless it meets their threshold minimum values of assets to justify their compensation that is based on some percentage of the underlying assets. So we've gotten creative on how to make sure a trustee the right trustee gets designated in the event of the vacancy in the office of the trustee. So it's just be something we'd have to talk through and come up with the best alternative. Michelle says, say you all live in the same state. Years later, you expire and your child is relocated to a different state. Does the trust still follow them, Lise? Yes. Why that capital LEA apostrophe S is there? That threw me off. So yeah, you can leave things. You all live in one state family. You've got a heir who lives in another state. No problem. You can leave things. Most of the trust terms in trust these days, they're typically applicable in every state. Yeah, every state does have their own trust code and trust provisions, but the kind of stuff we're talking about here, it's really applicable in all the states. So no problem there if you have a child who either lives or moves out of state. Do you recommend a child, Alex, to be a co-trustee while I am still alive or a successor trustee after I die? Well, typically, we're talking about here assets that you leave to your child when you die. So the trust really just sits there with no assets until you die. So, so it really doesn't matter who the trustee or co-trustees are while you're alive, unless for some reason you're adding assets to that trust, donating assets to that trust while you're alive. So if you are donating assets to that trust while you're alive and the trust assets are relatively minimal compared to what's going to go there when you die, may not be a bad idea to make that child a trustee or co-trustee, to give them a little bit of a trial run where they're managing, and I'm pulling these numbers out of thin air, they're managing $50,000 of trust assets instead of after you die when it's managing $1 million of trust assets. So lots of different options there. Lots of questions today on trustee, co-trustee stuff. It's all good stuff. Christy, I need to make sure my daughter only receives monthly. You stopped right there. I think what you're saying, Christy, only receives monthly distributions for the inheritance. So real common. I've worked up some formulas, Christy, and so sounds like you would want to say, okay, when I pass away, X or X percentage or whatever of my estate goes into a trust for my daughter. My daughter will get monthly distributions, and those monthly distributions, you could set up a number. Let's say you wanted your daughter to get monthly distributions of $4,000 a month. You could also provide that gets adjusted for inflation. So for the first year when you die, she gets $4,000. The next year it's a little bit more because it gets adjusted for inflation. That $4,000 number could be adjusted for inflation from the date that you signed your trust. So if you pass away in 20 years, then in 20 years, that first year, maybe she's getting $6,000 monthly distributions. So lots of different options there on the monthly distributions. Also, lots of different options on allowing a trustee to make additional principal distributions for various needs, such as health, education, maintenance, and support. LJ, you're an all-star there. You're welcome, and you're a top contributor. So it really helps out. I love the contribution. Tyler says, Grandma has a $2 million IRA and 2 houses. How do you split the house's value up and the tax consequences if one of the kids wants to live in the house that she owns? So good question. So sounds like what you're trying to do is leave one of the houses to a child outright, and maybe that child gets less of the IRA. That's a tough one to calculate if you want to make it perfectly equal, because the recipients of the IRA will owe income tax on that. So they're really, if there's two and there's a $2 million IRA, they're not each getting $1 million. They're each getting $1 million pre-tax. Whereas if you get a house, you don't owe any income tax when you receive a house as an inheritance. So that's a tough one. Maybe you just leave everything straight down the middle. And then when grandma dies, the child who is inheriting half the house and wants all of the house can then use some of their after-tax IRA money to buy out the other co-owner's share of that house. So I'm on the fly here, and of course, we want to know a lot more. Paul, the problem, LJ, is today corporate trustees have outrageous threshold and cost a blade of fortune. It is a problem. Yeah. So there's no question. Corporate trustees are not the perfect answer. It's an option. And so you're right. I've had corporate trustees tell me, Paul, unless there's $5 million involved, we don't even want to get involved. Some much lower thresholds, some more. That seems to be the biggest problem. Now, corporate trustees also have fees, which generally I think they earn, and it depends on the value of the underlying trust assets. Might be in the range of 1% to 2%. They manage all of the investments. They do all of the accounting. They do all of the tax reporting, all of the accounting to beneficiaries. So anyway, that's the deal there. LD, on prior retirement account question, could an account be established and left to the inheritance account and the brokerage transfer the mandatory withdrawals directly to the inheritance trust? That we'll have to have a separate discussion about conduit trusts and accumulation trusts. Whenever traditional IRAs are left to a trust, it just automatically complicates things to everybody involved. It's really never easy, because now there's multiple people that have to understand these things, which are complicated to begin with. So whenever an IRA is left to a trust, boy, the questions come rolling in from the beneficiaries of the trust, from the CPA, from the attorney, from the financial institution. And so, but not saying we can't get through it, but it's possible. LJ, Paul, idea, do a future video on pre-mortem wills trust. Delaware offers out-of-state residents pre-mortem trusts. Okay. Louisiana resident could avoid will contests. So good idea. So noted. David Clark, can a U.S. trust include Canadian assets, or I would need to extend? I don't even want to go there on the kind of out of country assets. Depends on what those assets are. Are they financial accounts? Are they real estate? So I'm going to pass. LD Paul, thank you for your time and sharing. You're welcome. Larry Bakersfield, good. California. Shane, is it advisable to make a RLT into an irrevocable trust while the grantor is still alive? Would like to see for myself how the process all comes together while I'm still alive. It's possible. Yep. So I would want to know why, and maybe you just said it right there, why you'd want to go from having complete control over things to limiting your control over your estate. Sometimes people want to do that. Sometimes we'll get a married couple and both of the spouses will tell me, Paul, we want this trust we have. We want to avoid probate and get all those benefits of a trust. But what we really want is we want to make sure the survivor of us doesn't do something stupid after one of us dies. So we would like our entire trust to become irrevocable when one of us dies. So there are some reasons, and you perhaps put a valid reason, like to see for yourself how it would kind of as a trial run happen. So yes, you can create or change a revocable trust to an irrevocable trust, or depends on the terms of your revocable trust. You may need to remove assets from your trust and put them in a new irrevocable trust. So lots of options there. Good question, Shane. Tyler, how would you handle an inherited IRA to reduce taxes to the lowest possible amount? Well, like I tell people for starters is, I always tell people, look, folks, when your child inherits your bank account, they're not going to pay any income tax on it. When your child inherits your house, they're not going to pay any income tax on it. When your child inherits your stock portfolio that's your brokerage account, they're not going to pay any income tax on it. When your child is the beneficiary of your life insurance, they're not going to pay any income tax on it. But whoever gets your IRA or your inherited IRA or their inherited IRA, whoever gets distributions from that, they're going to pay income tax on it, and there's no getting around it. Now, there's getting around it. Yeah, you could name a charity as the beneficiary of your IRA, and charities don't pay income tax. So, but you got to leave it to charity, and you can't leave it to your children. But no, the idea of just avoiding or minimizing or eliminating income tax on a distribution from a traditional IRA or inherited IRA, it just doesn't exist. Now, maybe you try to play the stretch out the distributions from that inherited IRA over several years. Yes, there's this 10-year requirement, but maybe you stretch it out over 10 years, never cause yourself to go into a higher income tax bracket. There's a little of that going on. So maybe you leave your IRA to grandchildren's trusts, for example, and those grandchildren aren't paying income tax yet. So they get distributions at a at a lower income tax bracket, but always hate seeing people leave things to certain other people just for tax reasons. You want to make sure you help the people that you want to help. All right, tough one there. That was a good question, though, David Clark. They are strictly financial assets, pass, except. Yeah, these things, they go up on YouTube and they're there forever. So I'm real conservative because I know somebody's going to say, well, Paul, you said this and really you weren't right. So thank you for the pass on that question. Okay, so that being said, you're welcome, Tyler. Come in tomorrow. Tomorrow is going to be another popular topic. It's all, while I've got my philosophical views on whether people should rely on the government to pay for their nursing home care and whether they really should kind of protect assets so the government pays for their care rather than they pay it for themselves. And I'll talk about that tomorrow. But that's what tomorrow's YouTube live stream is about: how to protect assets from nursing home expenses. So it's up there already. You can go on my channel, go on the live tab, and you'll see it 2:00 Central tomorrow. All right. Thanks for your participation, everybody, LD, LJ, everybody else. And we'll see you tomorrow, or we'll see you next time. Y'all take care.